Good afternoon, and thank you for joining today's session. My name is Paul Gordon, and I'm a partner at Willans Solicitors, and I'll be chairing the session today. My team and I are rated in the Chamber's High Net Worth Legal Guide for our expertise in contentious probate work, and we will deal with a range of contentious trust and probate cases. Our aim today is to give you a brief overview of contentious probate and to give you the opportunity to ask questions with our panel of experts. I'm pleased that we are also joined today by Alison of Pennywise Consultants, who provides extremely useful services to lawyers when running cases in this area, in particular those cases brought under the 1975 Act. We work regularly with St John's Chambers, who, as you will know, are also very well known for their expertise in this area. And I'm delighted to say that today we're joined by three barristers from their commercial and chancery team, with talks by Daniel, the essential components of contentious probate, Annie, from caveats to subpoenas and the whistle-stop tour of contentious probate procedure, and lastly by Joss Knight, putting it all together, an interactive session on running contentious probate claims in practice. St John's will be in touch following the talk, so you may access the slides, and the session is being recorded, so you may watch it again at a later date and after it has ended. It will also be available for you to type any questions that you may have using the Q&A function on the side of the screen. And I would invite you to do so to get most from the session today. And we'll be looking at those at the end after the talk by Joss. So therefore, without further ado, if I can hand over to Daniel, who'll be talking about the essential components of contentious probate. Thank you.
Great, thanks, Paul. So the essential components of contentious probate, you have a will, someone's trying to prove it, and someone is challenging it. If we start by a simple definition of what a court will be looking for when someone's seeking to propound a will, seeking to find the last valid will of a free and competent testator. So if you analyze that little phrase, you get a variety of different areas to challenge a will. First of all, you are able to challenge the formal validity of the will. Is it valid? Secondly, did the testator have the necessary mental capacity to make the will? Are they a competent testator? Did they know and approve of the contents of it? Was it their will? Was the testator actually coerced into making a will they didn't want? Were they free? Or was the will procured through some form of deception, fraud, or forgery, something of that ilk? So I'm just going to whistle through those different areas for challenge pretty briefly. In terms of formal validity, we still take it from Section 9 of the Wills Act 1837, albeit it has been amended a couple of times. That section requires of a will, in order to be formally valid, that it's in writing, signed by the testator, in the presence of two or more witnesses at the same time, and that each witness signs the will and attests it in the presence of the testator. So there are a number of different requirements of Section 9, but generally the usual practice is that the will is drafted, the testator in a room with two witnesses and perhaps the will drafter, who reads the will over to the testator. The testator confirms that that reflects their wishes and then signs the will, and then the two witnesses sign afterwards, having witnessed the testator sign the will. That's what's required for due execution. You may have spotted down there at the bottom of the slide, subsection 2, a recent insertion as a result of COVID-19, which means that the word presence includes by means of a video conference. So the witnesses who have to be in the presence of the testator can be by way of video conference. And that's until, according to subsection 2, until 31st of January 2022. So it's only a temporary allowance. You may be wondering, if you look at those different elements, if you're seeking to propound a will, well, how do I prove each of those elements? And it could be quite difficult to provide positive evidence that the witnesses were in the room at the same time and actually witnessed the signature, especially if it was a long time ago and you're perhaps a beneficiary who had nothing to do with the execution of the will. Well, you do have the benefit of a presumption. If the will on its face is properly attested, the signatures are in the right case, in the right place, and then there is a presumption of due execution. So if the witnesses have signed it, if the testator signed it in accordance with Section 9, then the court will presume that it was properly executed. And that's not a weak presumption either. It's a strong presumption, requires a really good evidence to overturn that presumption, especially if there's a proper attestation clause. So something which says something like, signed by the testator as his last will in the presence of us, both present together at the same time, who at his request and in his presence and in the presence of each other have subscribed our names as witnesses. And by that clause, you can see that the testator and the witnesses both understood the requirements of Section 9 and were, by signing it, are saying that they complied with those requirements. So a court is going to be very hesitant where that clause is in place to make a finding that the will was not properly executed in accordance with Section 9. And there are even cases where both attesting witnesses come forward later and say, oh, the will wasn't properly executed, and that hasn't been sufficient or strong enough evidence to overturn the will. And the Court of Appeal has overturned a number of first instance decisions and said that the attesting witnesses have simply failed to accurately recollect what happened, and they prefer the presumption of due execution. So if as I did last week, if you receive witness statements from attesting witnesses saying the will wasn't properly executed, it can make you think, how on earth am I going to get this will propounded? Don't lose all hope, because there's this presumption which is strong and will require strong evidence to overturn. Okay, that's due execution. I'm going to move on to testamentary capacity. The test for capacity, the test we still use was set down in Banks and Goodfellow back in 1869. And the judge laid down 4 different requirements, 4 different elements of the test. And I'll just go through those briefly. The testator must understand the nature of the act and its effect. So they must understand that they're making a will, and that the will, the effect of the will be to dispose of the testator's assets after he's died. Secondly, must understand the extent of the property which he is disposing, so have some understanding of what's within his estate, what assets he owns, some idea of their value. Doesn't need to know exact values, but needs to know perhaps their relative values, so understand that their house is a significant asset in their estate, and that perhaps bank accounts hold relatively lower sums. And that usually is sufficient for testamentary capacity. Thirdly, be able to comprehend and appreciate the claims to which you ought to give effect. So be able to appreciate that actually different people will be expecting provision from the estate, so often spouses, children, other members of the family who are close friends, etc. And to be able to weigh up and make a choice as to who ought to benefit from his estate, and vice versa, who should be excluded from the will. So there must be an element of being able to choose between different beneficiaries. Fourthly, and this one is often quoted verbatim because of the colourful language that the judge used, which clearly reflects the level of psychological understanding at that time, and I will quote, the testator must not be affected by any disorder of the mind which would poison his affections, pervert his sense of right, or prevent the exercise of his natural faculties, that no insane delusion shall influence his will in disposing of his property and bring about a disposal of it which, if the mind had been sound, would not have been made. So those are the four elements of the test. Now, if the testator has suffered from dementia or Alzheimer's or something like that, or is very, very elderly and frail, then they may struggle to have the capacity to understand those four elements. But again, if you are propounding a will, it may seem difficult to prove that the testator did in fact understand and was capable of understanding those four elements. Because again, if you weren't there where the will was executed, if you weren't close to the testator at the time, you may not have very much knowledge of the testator's capacity, and indeed you're unlikely to be a medical expert. First off, you have the benefit of another presumption. So if the will appears rational on the face of it and contains no irregularities, then it will be presumed that the testator did have capacity. So that's the first thing to do, is to look at the will and think, is this rational? Does it fit with, not necessarily is it as expected, because the testator is free to dispose of his estate however he wants, but is it rational? Is it logical? And if so, then the testator will be presumed to have capacity. But if looking at the medical records, there's a history of mental illness, evidence of confusion, memory loss, you may see evidence of memory tests taken by medical professionals. If the testator is quite old, then the presumption will be rebutted, and it will be for the party seeking to rely on the will to establish that the testator had capacity. But even then, you're not required to prove that the testator actually understood the four elements of the Banks and Goodfellow test. You actually only need to prove that the testator had capacity to understand those elements. Now, it's quite a subtle distinction, but actually, if you only have to prove the capacity, then it's really a medical question. And you will need to look at the medical records. You'll need medical experts involved. Usually there'll be a retrospective capacity assessment done by an expert, a psychogeriatrician, who can interpret the medical records and give an opinion on whether they think the testator had capacity at the time the will was made. If you're acting for clients and thinking about how can you prevent a challenge arising on the basis of capacity, there is the golden rule. Now, this was formulated by Mr. Justice Templeman, as he then was in the 1970s, over the course of a few cases, helpfully restated in key and key in modern terms. And the golden rule is simply that if you are drafting a will for an aged testator, or a testator who has been seriously ill, or if you have doubts as to their capacity, then you should obtain the opinion of a medical expert at that time who can assess the testator and be satisfied that they do have capacity. They can then make a contemporaneous record of those findings, which can stay with the will file. And if there's ever a challenge as to capacity, then you can get up this report from the medical expert who met the testator, assessed the testator, and was satisfied that they did have capacity. It's going to be extremely difficult to persuade a judge that the testator didn't have capacity if such a contemporaneous note has been made by a medical expert. It's by no means a requirement, and if it hasn't been followed, it doesn't necessarily mean that the testator didn't have capacity, but it's going to mean that the judge is much more likely to accept the opinion of an expert making a retrospective capacity assessment. I note there at the bottom of the slide, Hawes and Burgess, and that is an interesting one to note, because the court preferred the evidence of the solicitor who had drawn up the will in favour of the expert evidence in the retrospective capacity assessment. And that will often be the case if the solicitor has had a course of dealing over time with the testator, knew them, and made a note when the will was made as to their assessment of the testator's capacity. And the courts will attach weight to the views of experienced solicitors who make such a note. I'm not so clear if often I find that solicitors use a pro forma when taking instructions for drafting a will, and there'll be a section on capacity, and sometimes you'll see that that's been left blank. Now that leaves ripe ground for argument, because one side will say, Well, the solicitor clearly didn't have any qualms as to the testator's capacity because he didn't even feel the need to consider it and write anything down. But then the other side is clearly going to say, well, the solicitor clearly didn't even give a thought to whether the testator had capacity and didn't really make any assessment. Now, the absence of a record made by the solicitor is probably going to be construed against the solicitor, so just be wary of that one. Now, I can't possibly pass over the irony of Lord Templeman as he then became, and the golden rule not being followed in his own case. And this came before the courts last year in Goss, Custard and Templeman, where it was alleged that Lord Templeman lacked capacity to make a will back in 2008. And again, there are numerous reasons for the judge deciding that he did have capacity, but one of those reasons was that his solicitor, who he had known for some time, was satisfied that an assessment by a medical expert wasn't necessary because he was so satisfied that that Lord Templeman had capacity to make the will. So beware of Hawes and Burgess. A recent interesting appeal, clitheron bond, you may have seen referred to in places, interesting for a number of reasons. Firstly, as to the relevance of the Mental Capacity Act 2005, now for a while it was queried whether the definition of capacity in that act overshadowed and replaced the test in Banks and Goodfellow. I won't go into the details of the test in the Mental Capacity Act because in this appeal, clitheron bond, the court decided that it hadn't replaced Banks and Goodfellow, but that Banks and Goodfellow remained good law and remained the test for testamentary capacity. Other interesting part of this decision was some clarity given on what is required to establish an insane delusion, which is that fourth element of the Banks and Goodfellow test. And the court found that it must be a false belief, which is both irrational and fixed. Now, the interesting factual element of this case is it's not, as is often the case in capacity cases, that the testator suffered from dementia or something of that ilk. In this instance, it was extreme grief, which was said at first instance to have been so severe that it resulted in the testatrix lacking capacity. The testatrix had lost one of her daughters shortly before she died. And as a result, it was found that she had an affective disorder, which led to the estrangement between her and her remaining daughter, as a result of some false beliefs which she held about that daughter. And the judge has made some comments. The actual appeal on this point has been adjourned, so we've not got a final finding on the facts of this case. But it seems that at least one of the delusions, the court is satisfied that it was a delusion, and that was that the testatrix falsely believed that the daughter, her surviving daughter, was the cause of her divorce from her husband. Now, that was patently wrong because the cause of the divorce was that the testatrix had discovered that her husband had been abusing this surviving daughter. And so clearly it wasn't the daughter's fault. It wasn't the daughter who had caused the divorce, but the actions of her husband. So that was a false belief. It was both irrational, there was no reasonable grounds for it, and it was fixed. And so it looks like the court may uphold the first instance decision on that point, that it was an insane delusion. So interesting one for showing that extreme grief could, in rare circumstances, be sufficient to reduce capacity. And for considering what amounts to an insane delusion. So that's capacity. Moving on to knowledge and approval. The court must be satisfied that the testator knew and approved the contents of his will. Again, if you're seeking to propound the will, you might think, well, how can I bring evidence to show that the testator knew and approved the contents of his will? It may be difficult. But again, you have the benefit of a presumption, which if the court is satisfied that there was testamentary capacity and that the will has been duly executed, there's a presumption of knowledge and approval. Now that makes sense because if the testator's had capacity and it's been properly executed, that means that two witnesses have seen the testator sign the will, The testator clearly had capacity to understand the will, so there's a presumption that that he knew and approved of its contents. That presumption is even stronger if the will has been prepared by a solicitor and read over to the solicitor before its execution, as is standard practice. So if it's been read over to the testator, it'd be a very strong presumption that they know and approve of the contents, otherwise they wouldn't go on to sign it. But if the suspicion of the court is excited, it will be for those propounding the will to show and prove that the testator did know and approve of the contents. So, for example, the suspicion of the court will usually be excited if a major beneficiary of the will has had his hand in getting it prepared and executed. So if you have a will which leaves the entire estate to a son, and you see the will file, and actually it was the son who instructed the solicitor. The son drove the testator to the appointment, was present for some of the appointment, etc., etc. You may find that the court wants to be sure in those circumstances that the testator knew and approved of the contents. So the greater the suspicion, the greater the burden on the proponent of the will. And again, if the will is simple, it will be easier to show knowledge and approval. And if it's more complex, then it's more difficult. And when we turn our minds to fraud later on, we will see why pleading knowledge and approval can be, or want of knowledge and approval can be useful. Right, undue influence. Now, unlike the claims that we've looked at so far, the challenges we've looked at so far, undue influence is something to be alleged by a party. If it's alleged by a party, they have the burden of proving it. So unlike capacity or knowledge and approval, where the propounding party has the burden of proof to show that the testator had capacity and knew and approved of the contents and that it was properly executed, even with the help of those presumptions which I've mentioned, the difference with undue influence is it's for the party alleging undue influence to prove it. Unlike lifetime transactions, there's no presumption that arises in contentious probate claims. The undue influence must actually be proved. Now, the keystone is coercion. So the testator is coerced into making a will they don't want. And there's a useful, concise summary in Hall and Hall, I've noted on the slide there. Pressure is so exerted as to overpower the volition without convincing the judgment. Now, what amounts to coercion is going to depend on the state of the testator at the time. So if you have a young, fit, strong testator, then the court is likely to need evidence of very forceful coercion to overpower that testator's volition. And compare that with a case of a testator who's very old and frail and maybe ill, then actually not very much at all will be needed to overcome and overbear their own volition. I've noted Ree Edwards on the slide there. It's a useful case which helpfully reviews the test for undue influence and some of these other grounds as well. And the judge in that case said that even simply to talk to a weak and feeble testator may so fatigue the brain that a sick person may be induced for quietness' sake to do anything. A drip-drip approach may be highly effective in sapping the will. So in those sorts of circumstances, there's no need to look for any sort of physical coercion, although that may be there. But it can be a constant whisper in the ear, a nagging. That drip approach can be sufficient to establish undue influence. As I've mentioned, the burden of proof is on the person alleging it, and it's not enough to simply show that someone had the power to overbear the testator's will. Must be shown and proved that that power was actually exercised and that the will was obtained as a result. Difficult to prove. It's not often successful. It's a difficult claim to bring, but you might find assistance from the view in Schrader and Schrader, which made a reasonable observation that it's in the nature of undue influence that it goes on when no one's looking. It essentially goes on behind closed doors. And so it's very difficult to have direct evidence of undue influence. But the judge was satisfied that circumstantial evidence can be used. So it's a little bit tricky, those two statements together. You've got to show that the power to overbear the testator's will was there and was actually exercised to procure the will, but you can use circumstantial evidence to establish that. Standard of proof is the civil standard, so still the balance of probabilities, but the courts do consider it to be an inherently improbable course of events, undue influence, and so strong evidence and persuasive evidence is required to satisfy a court, even on the balance of probabilities, that there has been undue influence. Now, just a brief mention of costs. We could do a seminar on costs in probate claims. It's a big subject, but whereas in some instances, costs of the parties in a probate claim may come from the estate, if you are starting to allege undue influence, it's very unlikely that you'll get those costs from the estate. It's a very serious allegation. The courts take it very seriously. And if you look at the past cases, there are very few instances in which a party has alleged undue influence, failed, and still got their costs from the estate. It's much more likely that the usual order as to cost, that the costs follow the event, will apply, so that if you're unsuccessful in your undue influence claim, you'll certainly be paying your own costs, or likely be paying your own costs, and may well be paying the costs of the other side as well. So not to be undertaken lightly. Fraudulent calumny, somewhat similar to undue influence, but no coercion in this instance. It's about a poisoning of the mind. So you have someone who's close to the testator who casts false dispersions against the character of a potential beneficiary, and by doing so, essentially persuades the testator not to make a to make a gift to that person, or to cut them out of a will. Again, difficult to prove, rarely successful. You have to show that, difficult to get the evidence together to show that the influencer, let's call them, actually poisoned the testator's mind and was casting those aspersions, because again, that's going to happen when no one else is looking. There's a case called Konicki and Haywood, where the elements are broken down, the elements that were required to prove a claim of fraudulent calumny. And those are, you need a false representation. So clearly, if it's true, there's going to be no challenge. It must be made to the testator about the character of the existing or potential beneficiary for the purpose of inducing the testator to alter his testamentary dispositions, and made knowing that those dispersions are untrue or reckless as to their truth. And then the will is made as a result of that fraudulent calumny. So really important point is that the person casting dispersions must know that they are false or be reckless to their truth. If they believe what they're saying is correct, then there's no deception, and there's not going to be a successful challenge on this basis. So even if they are misguided, if they do believe what they're saying is true, then it will not give rise to a claim in fraudulent calumny. I've listed there a recent successful case at the bottom, 2017, and there the testator had excluded a beneficiary due to false representations that he had stolen money from her, and the will as made, which excluded that beneficiary, would effectively even things out, and that was false, and the person casting the dispersions knew that it was false. So very briefly, fraud, again, very strong evidence required, because it's a very serious allegation and the burden is on the person alleging fraud. It may be that a will has been destroyed by a beneficiary of an earlier will who has stands to benefit more from the earlier will, or that a will has in some way been altered and wasn't actually what the testator intended to sign. There was even a case where there was a use of a disguise, and the mother of the intended beneficiary disguised herself as the testatrix for the will to be executed. But they were found out, and that case on the bottom there is the criminal case where they were convicted and served time in prison. Now then, I mentioned earlier want of knowledge and approval. Because fraud's very difficult to prove and the burden is on the person alleging it, it may be simpler simply to bring a claim for want of knowledge and approval. Now, if there's been fraud, it's unlikely that the testator knew and approved of the contents of the will because they've been deceived by the fraud. So if you plead want of knowledge and approval, then the burden is on the propounder of the will to prove that the testator did know and approve of the contents. And then in that instance, you're relieved of possibly showing the fraud, because if there has been fraud, the proponent of the will won't be able to show that the testator knew and approved of its contents. Forgery, again, difficult to prove. You need a handwriting expert, which rarely give a conclusive answer. And if the will has been properly attested, then you often need to show that the witnesses were also in the forgery. But I've noted a recent successful case there facing Cunningham, where the beneficiary of the will had, the husband of the beneficiary had got an ex-colleague of his and his wife to witness the forged will. But again, it was found out in the trial last year, and the transcript of the judgment has been passed to the CPS for prosecution. So there we are on forgery. Good. Okay, well, I think I've probably gone over my time, so thanks for listening, and I'll pass over to Annie.
Thanks, Dan. I'm just going to try and share my screen. I hope that that's worked. So good afternoon, everyone. I'm now going to look at the procedures which are exclusive or particularly relevant to the types of claims which Dan has just taken us through. And I'm going to focus on the preliminary stages of a potential will challenge. And in particular, I'm going to look at those procedures which are available, firstly, to protect a potential will challenge's position pending the bringing of a probate claim. And secondly, to obtain information to facilitate a proper assessment of the merits of a potential will challenge. I'm focusing on the pre-action considerations in particular, as it's perhaps in this respect that procedures available in the context of contentious probate claims differ most from other types of claim, and because it's often necessary to act quickly in the very early stages before a claim is brought, and a familiarity with the procedures should make it easier to do so. However, I will also briefly go through the key ways in which bringing and responding to a probate claim differs from other types of proceedings, and how, in some cases, these differences can be used to obtain a tactical advantage. So, beginning with how to protect a potential challenge's position pending a probate claim, the first things to consider as a matter of urgency when a client expresses doubt as to the validity of a will will usually be whether a grant has been obtained, and if not, whether it's necessary to prevent a grant being issued. Checking whether a grant has been issued is done using a standing search. This is governed by Rule 43 of the Non-Contentious Probate Rules in 1987. As something of an aside, it is worth noting perhaps from the start that the replacement of these rules has been on the cards for almost a decade now. And to this end, draft probate rules were produced in 2013. These rules move away from the archaic language of the 1987 rules and seem to be drafted with a view to making probate processes more accessible. However, the 1987 rules continue in force for the time being, and in fact, I've been unable to find any indication of when it is hoped that the new probate rules will come into force 8 years after they were drafted. And the fact that the 1987 rules have recently been amended, in fact, just last November, might suggest that it might not be for some time. So I will focus on the procedure under the 1987 rules as that remains relevant for now. In respect of a standing search, that is made using Form 2, which is one of the forms helpfully included within Schedule 1's the 1987 rules, and then paying the fee, which is currently just £3, A standing search is then entered, and the person who entered a standing search is informed of any grant issued within the preceding 12 months and will be informed of any grant issued in the subsequent 6 months. And it can also be extended for 6 months at a time. So it's also important perhaps to note that the standing search procedure is the appropriate procedure where a client has no intention, in fact, of challenging a will, and instead wishes to bring a claim for provision under the 1975 Act. And bringing such a claim, in effect, accepts the validity of the will, unless, of course, it's paired with a probate claim. But where it's just a claim under the 1975 Act, a standing search enables the potential claimant to be notified of a grant and thereby keep an eye on limitation without improperly preventing the issue of a grant by using the caveat procedure. This distinction is perhaps all the more important following the decision in Parnell and Hurst, in which entering a caveat where only a 1975 Act claim was being pursued was held to be an abusive process, and those representing the claimant were heavily criticised for using the caveat procedure. But today we are concerned principally with challenging wills, so where a will challenge has been intimated and it transpires that no grant has yet been issued, a caveat should be obtained and obtained swiftly. While the issue of a probate claim also prevents the issue of a grant until that claim has been determined, clearly, ordinarily, a challenger would not wish to bring a claim without having an opportunity to investigate the position properly. Entering a caveat allows those investigations to be undertaken. Or, if a grant has already been obtained by the time you're instructed by the client, while a caveat cannot be entered and would in any case not serve any purpose, it's equally important, if not more so, to write to the personal representatives swiftly in order to put them on notice of the potential will challenge and to request that they do not distribute any or any more of the estate while it's investigated. And as to the caveat procedure itself, this is governed by rules 44 to 46 of the 1987 rules. The draft probate rules include replacement of this procedure with an objection procedure, but as again, there is no date for that implementation. I would just consider the position as it stands under the 1987 rules. And under those rules, a caveat is obtained using Form 3, which can again be found at Schedule 1 to those rules. And a caveat prevents any grant from being issued, apart from grants of the following kinds. So firstly, a grant to deal with specific property, which might be endangered by delay in administration. Or secondly, a grant pending suit, which is made during probate proceedings to ensure that the estate is managed and preserved for those found during the proceedings to be entitled to it. Or thirdly, a grant sealed on the day that the caveat is entered. And that is because a grant is deemed to be sealed at or just is deemed to be sealed just before 10 a.m. on the day that it is made. In addition, importantly, a caveat also does not prevent the issue of a grant where the procedure adopted by the person entering the caveat is vexatious or an abusive process, as was held to be the case in the very unusual circumstances of Ree Hancock deceased. In that case, the defendant entered a caveat pending the outcome of the defamation claim, which hadn't been served on the deceased prior to his death, and where the deceased was one of 31 defendants. And from the description of the claim, it seems that perhaps the inappropriate use of the caveat was the least vexatious thing about that. And a caveat lasts for 6 months unless the registrar directs otherwise. And during the last month of its duration, it can be extended for further periods of 6 months at a time. But it's worth noting that the subsequent periods of 6 months commence when the renewed caveat is entered and not on the date of expiry of the original caveat. So it might have an earlier expiry date than might otherwise be anticipated. So that's something to be aware of. A caveat can be withdrawn at any time before an appearance is entered, or a caveat can be discontinued in only 3 circumstances. Firstly, on an application by a person warning a caveat on the basis that the caveator has no contrary interest, or the caveator's claim is frivolous or vexatious. Secondly, by summons by consent between the parties, for example, where a settlement has been reached. And thirdly, after a citation. Often in contentious proceedings, the entry of a caveat is as far as the procedure progresses, as the existence of a dispute renders it unnecessary for any further steps to be taken under the 1987 rules, and instead minds turn to the probate claim. However, I will briefly go through the rest of the caveat procedure and how it interacts with the citation procedure for completeness. So following the entry of the caveat, a person claiming to have an interest in the estate may cause a warning to be issued in relation to that caveat. And that's done using Form 4, again at Schedule 1 of the 1987 rules. And that warning gives the caveator 14 days either to enter an appearance using Form 5 setting out the caveator's interest in the estate, which is contrary to the interest of the person issuing the warning, or more unusually, and certainly I've never seen this, to issue and serve a summons if the caveator has no contrary interest, but nonetheless wishes to show cause against the sealing of the grant. So again, it is important to move swiftly, particularly because if the caveator fails either to enter an appearance or to issue and serve a summons, on the filing of an affidavit showing the warning has been served and no summons has been received, a grant can then be issued. But if an appearance is entered, unless it is ordered otherwise, the caveat remains in force until a probate claim is brought. So the order of the procedural steps in these circumstances is usually caveat, warning, appearance, and then any probate claim is issued. A caveat is also a prerequisite for a citation. These are not really relevant to contentious business, as there are just three types. One requiring a citee to accept or refuse a grant, another requiring a citee to take a grant, and a third requiring a citee to propound a will. So a citation is principally a way of progressing the administration of an estate, not delaying it as a potential challenger would wish when considering a probate claim. So in summary then, the caveat procedure protects the potential challenger's position by buying time to investigate the claim, but it doesn't actually further the claim in any way. For that, the potential challenger will need to take advantage of that opportunity to obtain the information necessary to assess the merits of the potential claim. And in this regard, the key procedure in a potential will challenger's arsenal is a Larkin-Nugis letter. Larkin-Nugis is a Court of Appeal decision from 1979, in which a will was challenged for want of knowledge and approval and undue influence. But the deceased solicitor who prepared the will had refused to provide evidence as to the execution of the will and the surrounding circumstances, including the taking of instructions. And that was despite the existence of long-standing guidance from the Law Society that, where a serious dispute arises as to the validity of a will, beyond the mere entering of a caveat, and the solicitor's knowledge makes him a material witness, then the solicitor should make available a statement of his evidence regarding the execution of the will and the circumstances surrounding it to anyone concerned in proving or challenging of that will, whether or not the solicitor acted for those who are propounding the will. At first instance, the judge ultimately propounded the will, but made no order as to costs, despite the failed accusations of undue influence. On appeal, the Court of Appeal upheld the order and approved the Law Society guidance. In addition, Lord Justice Brandon added that when there is litigation about a will, every effort should be made by the executors to avoid costly litigation, if that can be avoided, and when there are circumstances of suspicion attending the execution and making of a will, one of the measures which can be taken is to give full and frank information to those who might have an interest in attacking the will as to how it came to be made. However, from the perspective of the will preparer answering the request, two key issues arise: privilege and confidentiality. In Larkin-Nugis, the preparer of the will also was an executor, and so the deceased solicitor-client privilege vested in him, and he could have chosen to provide the requested information and documentation. However, in Buckingham and Dickinson, it was held that the preparer of the will, who was not also an executor, should nonetheless have provided a statement as to the circumstances in which the will was made. However, despite the decision in Buckingham, it is still prudent, and certainly in accordance with the current Law Society guidance, to obtain the consent of the personal representatives in whom the deceased privilege vested on his death, and the consent of anyone who shared the privilege with the deceased, before providing the statement and any documentation. And if acting for those parties, a robust warning of the likely consequences of failing to consent to the provision of the requested information may well be appropriate if there is reluctance to give the necessary consent. The information sought by a Larkin-Nugis request will vary depending on the circumstances of each case. The potential challenger will usually wish to know, for example, how the deceased came to instruct the will preparer, how long the will preparer had acted for the deceased, and how well they knew the deceased, when, how, from whom, and by whom instructions were taken, how, if at all, the provisions of the will were explained to the testator's demeanour, including what indication, if any, the deceased gave that they understood that they were making a will, or the size or nature of their estate, or whether there are any signs of confusion, whether any departures from the deceased's previous wills were discussed, and if so, what was said, and where, when, and how the will was executed, including who was present. In addition, it will usually be appropriate to request a copy of the will file and any previous wills and the will files relating to those, in order to consider, importantly, what the position would be if the will challenge was successful, and with this, whether it would be worth pursuing at all. So, although it is now quite unusual given the likely cost consequences of failing to provide a copy of any testamentary document following a reasonable request, if requests are refused, sections 122 and 123 of the Senior Courts Act 1981 provide a means of obtaining a copy of any testamentary document and or details of the same with the assistance of the court. Under section 122, where it appears that there are reasonable grounds for believing that any person has knowledge of any document, which is or purports to be a testamentary document, the High Court may, whether or not any legal proceedings are pending, order him to attend for the purpose of being examined in open court. And the court may further require that person also answer any question relating to the document concerned, and if appropriate, bring the document. This section should therefore provide assistance where it's suspected that there is a testamentary document which is being concealed. Similarly, but without providing the opportunity to ask questions of the individual, under section 123, where it appears that any person has in his possession, custody, or power any document which is or purports to be a testamentary document, the High Court may, whether or not legal proceedings are pending, issue a subpoena requiring him to bring the document in such manner as the court may subpoena direct. Therefore, this section is useful where a testamentary document is known to exist and to be in the possession of a particular individual, but they are refusing to hand it over. And where an application under section 122 is made pre-action, as is likely to be the case given the likely materiality of this information to the assessment of a potential claim, Rule 50 of the 1987 rules provides that the application can be made by summons. However, if an application is more unusually required after a claim has been commenced, then the application can be made in accordance with CPR Part 23 as usual. Rule 50 makes similar provision in respect of an application under section 123, and where proceedings have not yet been commenced, the application supported by an affidavit is made to the principal registry or a district registry for a subpoena. Where proceedings have been commenced, the application is made for a witness summons. Paragraph 7 of Practice Direction 57 also provides assistance in respect of the procedure for applying for an order under either section 122 or 123. The fact that an interested party can simply apply for a subpoena for the will or to examine the will preparer as discussed seems to have influenced the Court of Appeal in Larkin-Nugis in deciding that the information and documentation should usually be provided when requested in an effort to avoid costs being incurred unnecessarily, including by avoiding the need for an application, with the implication being that such an application would usually be approved. Once the information and documentation have been obtained and considered, if the merits warrant it, a letter of claim can then be sent. There is no pre-action protocol specific to probate claims, and so reference should be made to the Practice Direction on pre-action conduct and protocols, and its provisions followed where possible. Another question which requires consideration at the early stages of a potential probate claim, and the answer to which is somewhat different from the other types of claim, is who should be party to that claim? The starting point is that anyone who can show that the outcome of the probate claim might affect their interest or potential interest in the estate of the deceased, even if only minimally, has a right to be a party to the claim. And case law underlines that those entitled to be parties can be a very broad category. For example, in O'Brien and Seagrave, it was held that a person entitled to apply for provision under the 1975 Act had an interest in the estate and so was entitled to bring a probate claim. And more unusually, in Randall and Randall, a creditor of the beneficiary of an estate, as distinguished from a creditor of the estate who would not have sufficient interest in a probate claim, was entitled to bring such a claim to challenge a later will on the basis that the beneficiary would inherit more under the earlier will. While who should be a party to a claim will clearly depend on the circumstances of each case, anyone entitled to administer the estate under an unrevoked grant will need to be made a party, and often those entitled under the will in issue or any previous will or on an intestacy will also need to be considered. However, particularly bearing in mind the breadth of the category of persons entitled to be parties, it will not necessarily be appropriate to add all of those entitled to be added, especially when considering the potential cost implications of doing so. To some extent, paragraph 4 of Practice Direction 57 offers assistance in this regard, as it provides that in giving case management directions in a probate claim, the court will give consideration to the questions: 1, whether any person who may be affected by the claim and who is not joined as a party should be joined as a party or given notice of the claim, whether under Rule 19.8a or otherwise, and 2, whether to make a representation order under Rule 19.6 or 19.7. This imposes on the court a positive obligation to consider making an order, making the judgment binding on non-parties, and/or making a representation order, both of which are possible means of making any judgment binding on all necessary persons at proportionate cost. However, it remains that the matter of who might be affected by the intimated claim will require careful consideration at an early stage in order to ensure that the claim can be pursued effectively, but without running up unnecessary costs. While it is helpful the court is required to consider these matters, the claimant should have a plan as to how they consider the claim should proceed as efficiently as possible, whether that is through the use of mechanisms such as representation orders or not. And ideally, this should have been the subject of discussion and, if possible, agreement with the other potential parties, so that the proceedings can focus on substantive issues and not procedural disagreements. Finally, having considered the pre-action issues, I'm briefly going to go through the key points to note about the early stages of probate proceedings. The first is actually a way in which probate proceedings might be familiar. In accordance with Rule 57.3b of the Civil Procedure Rules, a probate claim must be commenced using the Part 7 procedure, and therefore particulars of claim will be required. CPR Rule 57.7 then sets out particular requirements as to the contents of statements of case, including, for example, that any party who contends that at the time when a will was executed, the testator did not know of and approve its contents must give particulars of the facts and matters relied on. In addition, CPR 57.75 sets out a potentially useful tactical option available to defendants, as it provides that a defendant may give notice in his defence that he does not raise any positive case, but insists on the will being proved in solemn form, and for that purpose will cross-examine the witnesses who attested the will. And importantly, that if a defendant gives such notice, the court will not make an order for costs against him unless it considers that there was no reasonable ground for opposing the will. Therefore, provided that the defendant is willing not to advance a positive case, and so is not challenging, for example, the will on grounds of fraud or undue influence and is not seeking to revoke the grant, this can provide some cost protection. This is not only useful in and of itself, but the availability of such an option might also lend strength to the defendant's position during any negotiations towards settlement. CPR 57.5 then makes provision in respect to the filing of testamentary documents and evidence about them, which is exclusive to probate claims. It requires any testamentary document of the deceased person in the possession or control of any party to be lodged with the court, either when issuing the claim or when acknowledging service. Annexed Practice Direction 57, there is also the form a witness statement or affidavit providing evidence about testamentary documents should take. This compulsory early disclosure further underlines the futility of refusing to provide a proper Larkin Nubis response. The court's insistence on having details of all relevant testamentary documents before it from the start of proceedings also emphasises the importance to the parties of having obtained all of that information well in advance of bringing a claim, as without it, the merits of pursuing a potential claim cannot be assessed, nor the best means of pursuing the claim decided, including fundamental issues such as who should be party to it. Further, the position in respect of the filing of an acknowledgement of service by a defendant is also unusual. Firstly, under CPR 57.41, the filing of an acknowledgement of service is compulsory, so it's not open to a defendant just to file a defence alone. Secondly, the time available to serve an acknowledgement of service is 28 days rather than 14, but the time for serving a defence remains 28 days after service of the particulars of claim, so that's perhaps not particularly material. Thirdly, and importantly, in accordance with CPR 57.10, default judgment is not available in probate claims, but where no defendant files an acknowledgement or defence, it is possible to apply for the claim to be tried on the papers on provision of evidence of service on the claim on the defendants. So while default judgment is not available, there is an alternative cost-saving mechanism, and is one which is worth having in mind. So, having quickly toured through the early procedural stages of a probate claim, my final thought is that while there is and has been for some time now a focus on engaging properly with alternative dispute resolution, and with it the early exchange of information in all litigation, the availability of so many procedures in the context of contentious probate emphasises the particular importance of obtaining proper disclosure in respect of testamentary documents and the circumstances in which they were made as early as possible. It would, for example, be fairly disastrous to find out after having issued a probate claim that there is a prior will which is not open to challenge and under which the client receives less than they do under the will which they are challenging. So I would recommend that the available procedures are taken advantage of fully to try and ensure that the client is in possession of all of the facts at as early a stage as possible, particularly to try and avoid incurring unnecessary costs. So on that note, I'm now going to hand over to Joss, who is going to put the substantive matters and the procedural issues which Dan and I have been discussing together in an interactive session.
Thanks very much, Annie. That's very helpful. I hope I am now sharing my screen. Someone wave their hands vigorously if I'm not so doing. Dan's got his thumb up. That's excellent news. Good afternoon. My name's Joss Knight. First of all, thank you very much for hanging on in there and giving up your lunch break on what is probably the last day of summer this year. I'm finishing things off today with an interactive session. Now, if the concept of audience participation sends shivers down your spine and you're about to go diving for the leave Zoom meeting button, don't worry, I'm not going to be picking people out. There's simply going to be a few anonymous poll questions. It's all really very straightforward, so please do get involved. Rather than set you any pre-reading, for which I'm sure you're all far too busy, I'm just going to read out the short case study we're going to be dealing with today. In doing so, I realise I'm going to be breaking the golden rule of presenting, which is don't read a long text from slides. But what I do hope is that it will put everyone on a vaguely level playing field. Without further ado, let me introduce you to Cynthia Talbot. Here we are. Cynthia Talbot passed away on the 15th of August 2021 from natural causes, aged 88. She has two children, Danielle and Bernard. Her husband, Anthony, died in February 2000. Cynthia and Anthony lived at Bellevue Cottage in Taunton in Somerset, which they co-owned as joint tenants. Since the late 1990s, they've owned and run an artisan cider business called Scrumptastic, which had enjoyed moderate success, supplying a national supermarket. In 1996, they executed wills, giving minor pecuniary legacies to friends and charities close to them, and the remainder of their estate to each other. Both wills provided that if their spouse were to die first, the residuary estate would pass to Danielle and Bernard, their children, in equal shares. In 2008, they executed further wills, altering some of the pecuniary legacies, but leaving the other elements the same. Having previously lived locally and worked as the managing director of Scrumptastic, Danielle moved to Durham 10 years ago with her husband and children when headhunted by a large brewery. At the time, Anthony, her father, said that working in beer was a betrayal of everything we stand for. Cynthia couldn't tell whether he was joking. Sadly, the brewery closed down in 2018 and Danielle has been looking for work ever since. Bernard has always lived in Taunton. After Anthony died, he moved into Bellevue, helping care for Cynthia, his mother. He works locally. Prior to the pandemic, Cynthia, and during his lifetime, Anthony, used to travel up to Durham once or twice a year to visit Danielle. The last couple of times, Cynthia gave Danielle a check to cover household bills and expenses. We're getting there, I promise, nearly done. However, Danielle did not see her mother after the first lockdown commenced. Occasionally, she did manage to speak to her on the phone, but was limited by Bernard, who explained, "We can't be sure that COVID can't spread down the phone line." During a conversation around May 2020, Danielle recalls her mother being confused and talking about soldiers in uniform watching her from the bushes. She reassured Danielle that she and Anthony would come and visit again soon. Bernard and Cynthia did not come out of lockdown at all. Danielle last spoke to them at Christmas 2020 when they argued because Bernard would not let Cynthia get vaccinated. Bernard also suggested that Danielle was selfish for having moved away and suggested that she had stolen money from Scrumptastic in the process. Finally, Bernard rung Danielle on the 1st of September 2021 to tell her that Cynthia had died. He told her that in the summer of 2020, she had instructed willing, cheap and quick solicitors to draft a new will, appointing him as executor and leaving the entirety of her estate to him, Bernard. He said Cynthia was disappointed in Danielle for abandoning her and for willfully damaging Scrumptastic. You act for Elm Tree solicitors, who have acted for Anthony, Cynthia and Scrumptastic for many years, including drafting their previous wills. Danielle approaches you to ask for your assistance. She says she was close to her parents, that Bernard is domineering and jealous, and that the allegations about her conduct with Scrumptastic are ludicrous, easily disprovable, and her mother would not possibly have believed them in her right mind. Now, there's a fair amount to unpick there, and I'm conscious this is all new to you, and you don't have a chance to scroll back and look at some of the detail. But there are the brief facts. And I think what we'll do, Emily, is just go straight into the first question to see which of the possible heads of or causes of action there might be. So, Emily, can you put up the first question? So, which of these claims are worth investigating further? It's a multiple choice question, but tick all the ones that you think might apply. There's A to J. Emily, let's give people sort of 20, 30 seconds or so. There's no great magic in this, and obviously we haven't got a great deal of information at this stage. So just tick what you think is relevant. Okay, Emily, I don't know whether we've got some answers, all the answers, hardly any of the answers. But perhaps if we're there or thereabouts, then we can publish the results. And here we go, the scores are in. Let's see what's in play. First of all, a lack of testamentary capacity claim, 88% or 49 out of 56. I think that's got to be a possibility here. There are obviously two key pieces of information that were in there. One of which is, well, firstly, she's old, and the will was executed quite near her death. We also heard her in a phone conversation, the last conversation that we had with her, talking about soldiers in the bushes. That might be true, but more likely than not, it sounds like some kind of delusion. We also heard, of course, that she was making promises that she and Anthony would come up and visit Danielle soon, but we know that the timeline's a bit wrong, and Anthony was dead for some time by this point, so she's clearly perhaps not got a total grip on reality. Want of knowledge of approval, little fewer of you at the moment. I think you're right at this stage to be a bit cautious. There's not a great deal of evidence to show that there was want of knowledge of approval, other than those same bits of evidence that we've just seen. But we do know that we've got new solicitors on the scene. It's not immediately apparent why she wouldn't have used her long-standing solicitors. And we don't know for sure what Bernard says about there being this new will that was prepared by solicitors, because we haven't seen a copy. Undue influence, 82% of you think that might be a valid claim. That's got to be a consideration here. We've got the exclusion of not only Danielle, but also all the other charities and pecuniary legatees that have been taken out. and we've got a situation where Bernard is holed up in the house with Cynthia, controlling some aspects of her life, for instance, vaccinations, and also the ability potentially of how much she can talk to her daughter. So it is ripe for a possible undue influence claim, I would say, though of course, harking back to what Dan said, it's a difficult claim to prove. You can't just prove it as a possibility. It's got to be a bit of a certainty. So cautiously worth investigating. Fraudulent calumny claim, again, slightly fewer of you here. There's really not enough to say with any certainty at this stage. But what we do have is Bernard suggesting to Danielle that one of the reasons that he is angry with her and possibly Cynthia is angry with her because of her actions in relation to business 10 years ago when she departed. So there's the very early stages of that, but not a lot. Rectification, just one of you thinks there might be a claim of rectification. Again, I suppose it's possible, but it doesn't look much like it. If there's a will that says everything is going to Bernard, it doesn't seem to me to be a case where there has been a clerical error and one could make a section 20 application to say that the will doesn't contain the testator's instructions properly. Forgery, again, just a couple of you, I think I probably agree at this stage. There's always a possibility, I suppose, that when we get this will, we think it wasn't, that actually Cynthia had absolutely nothing to do with it. But it's a pretty rare claim, as again, Dan pointed out. Inheritance Act claim, yeah, I think 38 of you are probably right. That's certainly worth investigating. It sounds like Danielle had a pretty decent job a couple of years ago, but she's now in a potentially precarious financial situation. It's a relatively large estate. She's an eligible claimant, so it's certainly worth considering there at this stage. And then finally, the professional negligence claim, possibly in relation to this, though, of course, it's very difficult for us as a beneficiary to bring a claim against solicitors who've drafted the will, except in the White and Jones exemption, and I'm not entirely sure that would apply in this circumstance. But in summary, I think the key ones there are the first four: capacity, want of knowledge and approval, undue influence, fraudulent calumny, and an Inheritance Act claim. And those are the ones that at this very early stage you should have at least half an eye on, and should be looking to investigate. Okay, thanks very much for everyone for your answers. Let's just look very briefly at a couple of those different claims. Firstly, knowledge of an approval. I'm not going to dwell too much on this because obviously Dan has covered it. But the key element I draw your attention to, which Dan has already covered, is that where you have a will that is executed by a solicitor, and it appears that instructions have been given by the deceased, it's very difficult in those circumstances. And there is a very grave and strong presumption that the will has been duly and properly executed by the testator. These are a couple of quotes, Gillen, Woodman, and then the older case of Fulton and Andrew, which are pretty useful if someone is bringing or you're seeking to bat off a proposed knowledge and approval claim, and you have a will that's been executed by solicitors, instructions have been given, and so on. But there is some hope, and some recent hope. Middleton and Borman, recent case from last year, fascinating judgment. I urge you to read it if you are interested in knowledge and approval. I'm certainly an evangelist for knowledge and approval claims. I think they're often unforgotten, or they're often forgotten, rather, amongst the more glamorous undue influence and lack of capacity claims. Big benefit, as Dan says, the burden is on the propounder of the will, not the challenger of the will, which is obviously the case in undue influence claims. Milton and Borman, this was a case where instructions did appear to have been given by the deceased to a solicitor or a will writer, and they were recorded and set down. And rather than bring an undue influence claim or indeed a capacity claim, the claimant rather ambitiously just brought a knowledge and approval claim, despite the quotations we've just seen. Nevertheless, it paid off, and the judge said that there was a lack of knowledge and approval. And he said this: is this a case where the deceased changed her mind, flip-flopping again and again? I think not. Is this a case where the deceased being forced or unduly influenced into signing documents she did not really want to sign, i.e. undue influence? Again, I think not. Instead, once again, so I find, the deceased was willing to sign whatever important documents were put in front of her by a member of her family, without any real appreciation of the detail and effect of what she was signing. Judge came to his conclusion again, even though the deceased gave instructions to the will. Now, there were certain factual circumstances which led to that conclusion, but I have to say, probably chief amongst them was the fact that the judge clearly took a dislike to the defendants in the claim, who were the beneficiaries under this new will, and believed them to be exerting some kind of controlling influence. And I would certainly suggest that in any undue influence claim, any knowledge and approval claim, really tarnishing the other side cannot help you enough, because if the judge thinks that they've been up to no good, that is the first step on your way to succeeding. It's obviously not the only step, and you've got to do a lot more, but you want the judge to be casting a critical eye over those that are benefiting under the will. Just to row back from what I've said in relation to Middleton and Borman, perhaps to dash some hopes, Coles and Reynolds is another case. That's a dismissal of a knowledge and approval claim. There was heavy involvement in the production of the will by the beneficiary, i.e. the defendant in the claim, but nevertheless, the judge said, look, the deceased gave the instructions herself, and in that case, the presumption applies, and so the knowledge and approval claim failed. Moving on, undue influence. Again, Dan has covered this. Really important factor in this case, potentially, is the physical and mental strength of the testator. And we've got the Edwards and Edwards quote about a frail testator being more easily overborne than a hale and hearty one. Again, the famous quote from Hall and Hall, Dan read it out. It's about being led, not driven, which would allow for a valid will to be executed. And the will must be the offspring of the deceased's own volition and not the record of somebody else's. Cannot emphasize enough, cannot be a possible theory about what happened. It must be the only conceivable possibility. And again, in Edwards and Edwards, the burden of proving it lies on the person who asserts it. It is not enough to prove that the facts are consistent with the hypothesis of undue influence. What must be shown is that the facts are inconsistent with any other hypothesis. So that is a high burden. In the current case, again, you've got the makings of it here. We have Cynthia locked away with Bernard, who appears to be controlling aspects of her life. And we have a will in the teeth of two previous wills that were pretty consistent, giving equal benefit to the siblings and also to notable charities and pecuniary legacies, and all that dispensed with in favour of Bernard. But that's a theory. Undue influence at this stage, I think, would probably need a little more. Fraudulent calumny. Again, most of you picked up on this. It's about poisoning the mind, Edwards and Edwards. Now, how do we get to it in this case? The route, I think, would be, we obviously need to see the will file first to see what the solicitors had recorded in that. But the likely route is that Bernard was dripping poison into his mother's ear, saying that Danielle had been siphoning money out of the company during her time there and using this to encourage Cynthia to change her will. But word of warning in relation to this, we've got to show that Bernard knew that these accusations were untrue, because if Bernard believed them as well, even if they were faintly ludicrous, he was just telling his mother what he thought was right. It's got to be poison with the intention of changing the will. So Bernard must know that these accusations were untrue. And also, secondly, we've got to show that they had a material impact on Cynthia changing her will. At the moment, we don't have enough information, but certainly worth investigating. Incapacity, well, what's the evidence here? Well, she's old, near the end of her life, not in itself nearly enough, but there is some evidence of paranoid delusion, which we've discussed. Be very cautious of that, though. It's based on a single unevidenced call with Danielle. And I think on that basis, it's unlikely to be enough at this stage to persuade the judge that any of the first three limbs of the Banks and Goodfellow test are met, namely, did she know about the nature of an effect, extent of the property, and to comprehend and appreciate the claims on the estate. The fact that she's forgotten her husband's death potentially might indicate that she didn't understand or comprehend the various claims on her estate, but she hasn't included provision for him in that. What about the fourth limb, the limb about paranoid delusions, perversion of the sense of right, having an impact on the disposition? Again, this is where we might bring in the company information. If she believed Danielle had siphoned money off the back of out of the company, and she wouldn't have believed this, as Danielle suggested, if she was in her right mind, then potentially we have a paranoid delusion which has caused her to alter the will. And Walter and Smee, good example of something along this lines, where it said it will thus be seen that in acting as she did, the deceased was motivated by factors which are the product largely, if not wholly, of misapprehensions. These misapprehensions were the result of her dementia and the effect of it upon her cognitive faculties. In short, she reached false conclusions concerning the Walters' behaviour, which led to her disillusionment with them at the time of the will. These false conclusions were one which I find she would not have reached but for her impaired mental state. There's been quite a lot about this kind of claim, incapacity claim recently, where you have a frail and potentially cognitively impaired testator who believes something about excluded beneficiaries. Re Bellis, the 1921 case, has suddenly re-emerged from obscurity and has been cited in a number of cases. In that case, the testator wrongly believes she benefited one child over the other during her lifetime, so she thought she'd even the score in her will. The judge ruled that this was a delusion, and she wouldn't have made the disposition had she not been suffering from that delusion, and thus she did not have capacity. Ball and Ball is a 2017 case of Master Matthews, or His Honour Judge Matthews now, here in Bristol. In that case, the testator wrongly believed that, or as advanced by the claimants, that her now deceased husband had not committed sexual abuse against their children, and she'd excluded the children on this basis. It's a very sad case. But the judge said that even if it was true that she had used this as a rationale for excluding her children, this was not a delusion. It was potentially a mistake, but that's not enough. And again, that's what happened in the Templeman case that Dan was talking about. The claimants tried to advance the case that there had been an illusory belief that the Lord Templeman had, that he hadn't already dealt with the property, whereas in fact he had already dealt with the property. If he'd understood that, he wouldn't have created a new will dealing with the property, because he would have known he'd already dealt with it. But the court dismissed this, said this isn't a delusion. If it's anything at all, it's probably a failure of memory. In relation to the incapacity claim, we need a lot more information. We need some medical records. We need a record of the will instruction. Your first task, having been instructed by Danielle, should be answering these types of questions. What are your potential claims? Well, we've looked at those. What information can you get from Danielle? Well, we need to know about previous wills, potentially a mutual will. We need to know about the charities that would have been benefited under the previous will. We need to know about the business, how falsifiable is this potential allegation about her and the company, and what evidence is there that her mother believed it at any point other than in the last year of her lifetime. What documents do you need? Well, you need the medical records, obviously, and you need the will file. Those are the two most important things. Who else should you speak to? Well, potentially anyone involved in the business. You need to probably speak to the witnesses to the will once you get a copy of that, and probably any friends in the local Taunton area or any family who might be able to give you some information about their abilities or efforts to talk to Cynthia and whether they were excluded, for instance, by Bernard, which might help you in your undue influence claim. So let's look at our next question, which is about getting hold of the will. Emily, can we put that up? Simple question, yes or no. Do you have a right to demand the will or to see a copy of the will in this instance? We're a bit short of time, so I'm going to give you 10 seconds in which to answer that. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Yes or no? Okay, Emily, what are the scores on the doors? Oh, 60-40, very close. Yes and no. Well, the answer to the question is it depends. The will, it sounds like at the present stage, probate hasn't been granted. We know that she died on the 15th of August, and Bernard has only got round to telling us on the 1st of September. If it has, probate has been granted, which seems unlikely, then it's a public document. We can get a copy from the probate registry. If it hasn't, it's probably in the hands of the solicitors, possibly in the hands of Bernard as executor. We don't have a right to see that will at this stage because we're not beneficiaries of the will. In fact, we're just disappointed beneficiaries under a previous will. But of course, as Annie points out, there is a route for us to go, and we can make an application under Section 123 of the Senior Courts Act in order to get hold of a testamentary document and see Practice Direction 57, paragraph 7.1 for the procedure. The simple way around this is to demand it from Bernard, threaten an application, threaten costs. Hopefully he will cough up. Right, let's go on to the next question, Emily. Question number 3. So are willing, cheap and quick obliged to provide a Larkin Nugas response and disclose the will file? Single choice, yes or no. 3, 2, 1, go. Emily, let's have some results. Okay, 80% of you say yes, 20% of you say no. Slightly tricky one, this one. I think technically the answer is they don't have to provide anything. Now, we know that the executor, or at least Bernard, has told us that he is the executor. So willing, cheap and quick aren't the executors in this case. Therefore, those privilege, which starts with obviously the testator during their lifetime and passes to the executor after the deceased's death, that lies with Bernard at this case. And it's for him to waive it, and the solicitors, if they're doing their job correctly, will ask him for his authority to waive it. The guidance from the Law Society is that you should, if you are a solicitor, should obviously be seeking authority from the executor to provide a Larkin Nugas response. It looks incredibly bad if that's refused. You can also threaten a pre-action disclosure application, but it's not as simple as saying that willing, cheap and quick are simply obliged to provide a Larkin Nugas response. They certainly should, but they should certainly get the authority first. Medical records. Let's have a look at the next question, Emily. Which of the following are you entitled to see? GP records, hospital records, social service records, or none of the above? 5, 4, 3, 2, 1. Emily. Everyone quick off the mark. 66% of you say none of the above. Well, the answer is slightly complicated, but in essence, the executor has an absolute right to see the medical records because they are in the shoes effectively of the deceased. You have a claim potentially under Section 3(1) of the Access to Health Records Act, which provides that the patient's personal representative and any person who may have a claim arising out of the patient's death can get hold of the GP records and the hospital records. It doesn't cover the social services records, but they've obviously got to be satisfied that you fit in with that criteria, and whether a claim actually exists lies with the record holder according to guidance notes by the Department for Health. In terms of where to find them, very quickly, GP's records will go to Primary Care Support England or the Welsh equivalent in Wales. Hospital records will be the access to medical records team at the hospital where they were treated. Different trusts do different things. Social services not covered by the Act, but the best way to get hold of them rather than go off with their own bat is to get the executors to agree and send a joint letter. There is a ACTAPS practice note precedent for this letter, by far and away the easiest way to get sorted, and you should be agreeing to this if you are acting for the executors. Right, Larkin Nugas, just going back, this is your information that you received. I'm going to dash through this because we're running short on time. But we find that they received an email from Bernard explaining the changes his mother wished to make. Instructions were then taken by Zoom. Bernard was present initially, but Cynthia was happy with the technology and he left when requested by the solicitors. As Cynthia explained to the solicitor, she wished to exclude Danielle because she had stolen from our company and she never visited anymore. She wished to reward Bernard, who had also looked after her and did everything for her. Right, issuing procedure. Emily, next question, coming a bit thick and fast here. How should you issue the procedure if you think there is both a probate claim and also an Inheritance Act claim? Should you issue a Part 7 claim, bringing all claims, issue a Part 8 claim, bringing all claims, issue the probate claim under Part 7, Inheritance Act claim under Part 8, or should you do the probate claim on Part 7, pursue that, and if it fails, bring the Inheritance Act claim? 5, 4, 3, 2, 1. Oh, issue a Part 7 claim, bringing all the claims in one, 43%, that's the winner. Tricky issue, because you have, in these circumstances, CPR 57.3 that says a probate claim has to be under Part 7, and CPR 57.16, which says you must use a Part 8 claim for an Inheritance Act claim. So there's a tension there that's not immediately solvable. The answer to this actually is probably C. You've got to issue the claims separately and then deal with them separately. Or what you shouldn't do is option D, issue the probate claim, because you run the risk of missing the 6-month time limit. So yeah, the answer there is question C. Next question, Emily. Once a claim has been issued, should you request the two claims are consolidated, request the court stay the Inheritance Act claim pending the outcome of the probate claim, request the two claims be listed together, allow the two claims to proceed independently? 5, 4, 3, 2, 1. Emily, what have we got? Oh, what's the winner here? Request the court stay the Inheritance Act claim pending the outcome of the probate claim. I think that's a reasonable suggestion. That's what was suggested in Fox and Pettigrew. However, it's not one the Court of Appeal liked very much. They said there would be a duplication of the evidence, or a potential duplication of the evidence. I think in the circumstances, and even though you're going to incur the costs of managing both claims, the answer is to request the two claims be listed together under 3.1H. You can obviously give the court the option at the case management, but you'd certainly ask for the first case management hearing to be conducted together. We're short on time, so I think we will leave this as the last question. Emily, if you could bring that up. Sorry, the next question we will treat as the last question, if that's unclear. Which do you consider that to be the strongest claim in light of the Lark and Nugas letter and the things we've heard already? No right or wrong answer, so we'll deal with this pretty quickly. 5, 4, 3, 2, 1. Lack of capacity, clear winner there on 46%. Interesting that I don't think there's a great deal of new information we found under Lark and Nugas letter. We certainly, what we found out hadn't happened rather, was there hadn't been compliance with the golden rule as far as we could see. This had been conducted by Zoom, heavy involvement from Bernard. So I would certainly agree that the two best claims, the undue influence claim and the lack of capacity claim at this stage, but the capacity claim is clearly awaiting medical records, because these are going to potentially sink your claim or not, as it were. So that's a very quick gallop through a practice example of the types of issues that are going to arise. I appreciate it was quite quick. We do have now time, I think, for some questions from everyone else.
Yes, thank you, Dan and Ian Joss, for those insightful presentations. We are running short on time, and I'm conscious that therefore that may limit the time available to us, but we've had various questions put to us, so perhaps if we could just skip through a few of them if we can. Maybe one for Dan to start with. It says, is a copy of an executed will propoundable when the original is missing?
Thanks, Paul. Interesting question. You really need to know where the original was, because if the original was in the possession of the testator and it's gone missing, there's a presumption that it was revoked. So you need to know why has it gone missing, and you'll need to establish that it wasn't intended to be revoked. And if you can get over that burden, then you can prove a copy of a will.
Thanks, Dan.
Should I just deal with the second one, Paul, as well? It's a similar one. Is a will propoundable when the witnesses' names and addresses have been removed from the executed will? Well, the requirements of Section 9 only require the witnesses to sign the document. So as long as the will is signed, there's no requirement that the addresses and names are there. However, if the names and addresses have been removed from the executed will, it's a little bit suspicious. The court might be a little bit interested to know why they've been removed. The presumption will still arise. The presumption of due execution will still arise if the witnesses have signed the document, but it may be weakened by the fact, significantly weakened by the fact that the names and addresses have been removed. So you'll want to find and locate the attesting witnesses if you can, so that they can attest to the due execution.
I agree with that, Dan. Obviously, you look at the question of when it was signed and was it duly executed at that stage, and if assuming those addresses were there at that point, then it suggests it was duly executed. I guess the next question is, has there been some kind of implied revocation? And obviously you'll need to investigate further, but it doesn't sound like it to me. The critical question, I suppose, is who's been scrubbing out the names, the testator or somebody else? If somebody else, then obviously, unless it's the testator's instruction, there doesn't appear to be any particular difficulty. In relation to the first question, it's Rule 54, I think, of the non-contentious probate rules, where you can apply for a copy of a will, or indeed a fresh version of a will to be produced if it is missing, lost or destroyed. But obviously, you've got to get over that hurdle that Dan said about the presumption of revocation.
Thank you. A further question to the panel. This one may be for Annie. It says, I sometimes see that solicitors register caveats alleging invalidity, but also in the alternative, a 1975 Act claim, when the reality is that the invalidity claim is very weak. They refuse to provide or are slow to provide evidence in support of the invalidity claim, no doubt seeking to buy as much time as possible for the 1975 Act claim, essentially delaying the grant. I see this quite a lot. How is it best to deal with this information from a how is it best to deal with this situation? That's from a tactical perspective. Perhaps Annie, if you could deal with that.
Yeah, of course. I guess perhaps it depends on how long this delay has persisted. If it has been some time, then one option would be to to make a put up or shut up application. So apply to the court saying if they don't make their intimated probate claim within, say, the next 28 days, then we're entitled to apply for a grant. That would be one way of dealing with it. Although obviously you'd hope that you could avoid the cost of that application if possible, but it would be one way of putting an end to the matter, particularly where it's suspected that this is just a delaying tactic to enable them to investigate a 1975 Act claim, which in theory really shouldn't take that long.
Yes.
So that's one option perhaps. I don't know if either of the others have any alternative suggestions.
Paul, you said you come across this quite often. Do you have a view of how to deal with this, whether it's a bit of a try on just to delaying as a delaying tactic?
Essentially, we find this, some solicitors don't actually realise that they can't register a caveat for a 1975 Act claim. It's not, so we find that, so when you enlighten them to that, then often they remove it. But there are also those that do deploy it from a tactical perspective. And I think it's just a matter of maintaining pressure on them, because ultimately they will break because they know they'll be exposed to costs. So it's just pushing them towards that. But understandably, the executors aren't going to want to incur too many costs if it can be avoided. So it's sort of important to try and understand effectively what the real claim is from an early stage. So and also if you're acting for the executors, to adopt a position of neutrality as well. So it's you're trying to do two things at the same time. Be robust, but be neutral. I have another question here because it leads on ever so it's similar to that, which is leads on from your Josh's talk, where it says Josh has referred to a potential claim under the 1975 Act. What kind of information should I provide from a financial perspective at an early stage, and how should I best present this? I think if perhaps we can hear from you, Josh, and then also from Penny, actually, because I think that also is aligned with what Penny does.
Yeah.
Sorry, Alison, I beg your pardon.
Don't
Alison
worry.
or Penny.
Yeah, thanks, Paul. I mean, it's right to say that if you're running an Inheritance Act claim properly, you're doing a lot of work in the first instance. They are a front up type of claim, and the most important document is going to be the schedule of needs and resources. Now, I think people often make the mistake of long witness statements setting out the entire history of the family dispute and who said what to whom in 1982. But actually, the court is the schedule of needs and resources is almost invariably the most important document. You really do have to go into granular detail with clients who, in my experience, will give very broad brush answers if you let them give very broad brush answers. So you really need to nail them down on the detail. There are precedents available, but really you need to be setting out their expenditure into different sections as much as possible. And in my experience, rather than overstating their claim, normally what clients do is try and demonstrate that they actually live very frugally, in fact, probably more frugally than they do actually live. And so set out their schedule of needs, i.e. their general expenditure, far too low. You've also got to have half a mind on the pandemic as well, and people's expenditure has been low. And one way of getting around this is bank statements, but in case of pandemic, you'll need pre-pandemic bank statements, I would suggest. But really sitting down and going through them in granular detail about what their income is, their debts and their assets and their expenditure, and putting this in a schedule, and that is going to be the most persuasive thing when you're trying to settle it. But you certainly need it to be attached to your witness statement when you're issuing the claim.
Yeah. Can you add to that at all, Alison?
Well, I can. I mean, I agree that the income needs schedule is really important, and people find them difficult to do for a number of reasons. And that's why we like to think we can help, because what people tend to do is sort of concentrate on their personal spending. They sort of get more interested in thinking about what holidays and clothes and things they might have, but don't focus on the committed spending. And the committed spending is very often more than they think it's going to be. And generally people spend more than they think they do. It's harder for us to push a budget up than it is to bring it down. But that's why we talk to them and point them in the direction of all the things that they might have forgotten. So if it has to be an all singing, all dancing, all inclusive budget, then that's what we do. And hopefully a really good one can settle things at an earlier stage.
I mean, my view is I agree with you there. I think there can be a lot of costs racked up at an early stage with questions being asked by defendant solicitors, and then having to trawl through things on a periodic basis, refresh yourself. So sometimes to provide a fuller basis of your financial position at an early stage, I think can actually save costs. So thank you for that, Alison. So maybe just one more question, mindful of the time. This one perhaps to Josh, but maybe anyone else wants to answer. Are there any common characteristics I should be looking for within, sorry, is that one? Yeah, I should be looking for when considering a will file to assist establishing undue influence or want of knowledge and approval?
Yeah, well, looking specifically at the will file for undue influence or want of knowledge of approval, I think front and center has to be circumstances of the person you say is involved and perhaps unduly influencing this or guiding the hand of a incapacitous testator, and see what they were doing. I mean, an example we talked about, they were emailing and saying, look, this is what she wants to do. Can you draw up this will? And then even though there's a later meeting, we still got that evidence of someone driving the process. So look who arranged the meeting, who spoke to whom. There might be more than one meeting. Look to see whether the defendant or the primary beneficiary was present at that meeting, when they were asked to leave, how they were asked to leave. And then really what you're hoping for is a comprehensive record of the solicitor's discussion with the client. If there is, and some solicitors do it now, a transcript, then that can be either defeat your claim, but then at least you know, because you can see that the testator was able to answer the questions pretty easily and comprehensively, or perhaps the absence of any kind of comprehensive record, contemporaneous note from the solicitor, can bolster your claim, because it doesn't act to defeat by demonstrating that the testator was giving full and frank reasonings for their dispositions off their own bat. But really in the will file, you really are just looking at what the solicitor's written down, and that's never going to tell the complete story. You've obviously got to have a think about whether there's any, the solicitor has thought about obtaining medical records or indeed a doctor's opinion in line with the golden rule. If they haven't, that might be good news for your claim.
Thank you.
Paul, I don't know, anything to add from that, or anyone else?
I think there's another question here about the impact of COVID-19, and it might not be obvious from the will file, but also a good one to look at if thinking about undue influence is how isolated the deceased or the testator was during lockdown. Obviously, a lot of elderly people who would be making wills possibly will be very isolated, and if they are isolated, that makes them perhaps a bit more vulnerable to undue influence from other people, or especially if, as in the example that Joss gave, if the deceased is living with one person throughout lockdown, then that might make them also a bit more vulnerable.
Thank you. Well, I think we're running over a little bit. That's 15 minutes over. So I think if that's okay, we'll bring it to a close. But there will be a information sheet, a feedback sheet, which will pop up on your screen automatically after the session. And so please do ask any questions that you may have on there that haven't been answered today. That's to both Dan, Annie and Joseph, but also to Alison in relation to any support that she can give in relation to the 1975 Act. So thank you to Alison, to Dan, Annie and to Joss for today. And on behalf of myself and my firm at Willans, I'd like to again thank you for joining the session today. Goodbye to you all and enjoy the rest of your day. Thank you.